it's feeling that it's Friday, it seems, so there may be some delays. So I apologize in advance. So thank you so much for joining us. I'm very excited to see everyone here at our second session on this Foundations of Civil Procedure class for practice in the Nunavut Court of Justice. For those of you who don't know me, my name is Clare Cudmore. I'm the Executive Legal Officer for Court Administration at the Nunavut Court of Justice, and I have the pleasure and the privilege of providing support to the court registries of the Nunavut Court of Justice. So I'm always really excited to talk about practice and civil procedure, and I hope that you are excited as well. So today's section of the course is talking about interim and interlocutory practice, and there is a lot to cover. So I'm just going to jump right in. So just give me a second. I'm going to share my screen. Here we go. So if I can just confirm that everybody can see. I don't know if everybody's connected. Thumbs up. Okay, so like I said, and I unfortunately I tried, but my desktop Zoom client is not working, so I can't see the presentation and your beautiful faces a lot because nobody has their camera on other than me. But so if you have questions or there are challenges with the presentation, if you can please unmute yourself and speak, because I can't see the awesome thumbs up and the hand raises. So please feel free to just unmute yourself and jump in. So like I said, today we are here to talk about interim and interlocutory chambers practice in the NCJ, and this is session 2 of our Foundations of Civil Procedure in the NCJ series. So I will start this session like I start most discussions about civil procedure, which is the ultimate cheat code for dealing with the court and civil procedure, is to read the rules and to remember that the documents that you file with the court is your first impression. So my 3 rules about the rules are: love the rules with all their imperfections. And rule number 2, know which rules. And people, this one is important because there are multiple types of rules that apply in the Nunavut Court of Justice. We have the big rules, which I call the civil rules, because all for example, divorces are civil matters, but they are under the divorce rules. So we have the big rules, the civil rules, the divorce rules, the probate rules, the bankruptcy and insolvency general rules, all different types of rules that apply. And the 3rd rule is always, always, always double check the rules. So that having gone, what are we going to be talking about today? The first thing we're going to talk about is why civil procedure is important. And some of you who attended at the last session will have some of this reinforced. The second thing we're going to talk about is the rule requirements relating to notices of motion and affidavits. And that is going to be the meat and potatoes of the class. And then we're going to talk about practice tips and the procedural rules that relate to motion practice in the NCJ. And then we're going to have a charming discussion about NCJ chamber states and how to keep them. So first thing I need to say is a reminder, like last time, that civil procedure is a beautiful rabbit hole. This short snapper of a CLE is not intended to cover every single rule or procedural issue that may come up in motion practice. It's just a general overview, and we're going to be talking about in some detail parts 30 and 31 of the rules of the Nunavut Court of Justice. So please don't think that after taking this brief course that you will know absolutely everything there is, because there's just not enough time to go through everything that relates. Okay, so that's why I say read the rules, know them. Even if you think you know them, read them again. So why is civil procedure important? like we talked about last time, access to justice. Fundamentally, even though we were all told that in 2020, by 2023, we would be living in a Jetsons world and that we would all be working in paperless offices, the civil procedure, the paperwork that we file, is how our clients access justice. Nothing that happens in court happens without there being a piece of paper associated with it, right? The other thing to remember and to always turn your mind to is that there are issues of professional liability that arise when we are dealing with civil procedure. You are required, in accordance with the Code of Professional Conduct in Nunavut, Part 1.3 discusses competency to practice. There is a section 3.2 that talks about quality of service. Our clients expect that we know how to proceed in court, that we know how to file court documents correctly. And sometimes from time to time, the quality of pleadings becomes an issue before the court. And we're going to talk about that very briefly. Effective advocacy. How you present your documents and including all of the information that you need to include is very much a key component in being able to advocate effectively. And also, in a very real and tangible sense, your ability to prepare documents correctly and know how to proceed in relation to a particular matter helps ensure timely access to the court. Okay, and like I already discussed in terms of professional liability, the competency requirements come in, but also to flag in terms of professional liability, it happens that the court can actually order costs against us personally as lawyers if we take actions that are found to not meet our professional obligations in terms of pleadings and practice. And in a very real sense, people, the very first impression that you make on the court in terms of bringing a matter before the court is quite literally the quality of the pleadings that you put before them. These are things that judges notice. So I know that in the last training, I gave a quote from a case that it was before the Nunavut Court of Justice. And one of the things that I want to reinforce is the fact that we as lawyers spend quite a bit of time in different CLEs about specific areas of the law. There's for example, the Federation of Law Societies puts on week-long CLEs about family law and criminal law. We turn our minds to those issues all of the time. And it's important not to forget that civil procedure is an evolving area of the law and a foundation of your access to the court. So when you're considering, the fact that you are monitoring case law in relation to a particular practice area like the criminal or family, there is also case law that gives us guidance on how we engage in civil procedure. And these are things that you should turn your mind to. So, for example, I've listed on this slide 3 cases where this court engaged in discussions about the pleadings that lawyers put before the court. And we heard some very important guidance from the court, for example, in the first session of this series from the Adelaire case, which is referenced here. But MTVDI, the court made some comments about the contents of an affidavit filed by a lawyer in an ex parte matter, right? Cape Dorset Hamlet v. Polar Supplies. The court was asked to strike paragraphs in an affidavit that was before the court. And so, one of the things to remember is when you are filing documents, you need to consider that sometimes the quality of your documents become issues that are raised in cases, right? So, for example, and these are from outside the jurisdiction, the court comments and reminds counsel about their duties before the court, right? In Canada, and the Attorney General and Quadrini, the Federal Court of Appeal, says that the purpose of an affidavit is to adduce facts relevant to the dispute without gloss or explanation. The court may strike affidavits or portions of them where they are abusive or clearly irrelevant, where they contain opinion, argument, or legal conclusions, or where the court is convinced that admissibility would be better resolved at an early stage. And I think it's important for lawyers to turn their mind to the fact that sometimes the quality of the documents that you're putting before the court can be become the subject of the litigation. And so taking the time to review the rules and prepare pleadings in a way that doesn't give rise to these issues is an access to justice issue, because the costs of doing this can be borne by your clients and by the lawyer themselves. And so, I often suggest to people it can be thrilling and a little bit chilling to read some of the cases where the court has considered striking pleadings, like statements of claim that are filed that don't meet the requirements of the rules. And so, if you take one thing from doing this series, I hope it is that you understand the importance of reviewing the rules of court and understanding that the civil procedure that you use is an important part of your advocacy and duty as a lawyer. As the court in Saskatchewan recently noted, lawyers are not mere mouthpieces doing and saying whatever a client wishes. Lawyers are expected to bring their knowledge, their skill, their best judgment, and their experience to bear on their clients' issues. In this case, the lawyer filed an affidavit where the court found that the paragraphs were clearly inadmissible, and counsel advocated his duty to his client, to the other parties, and to this court. So, what should we be thinking about when you're drafting pleadings? So, things to remember: a well-presented notice of motion during interlocutory practice is the first opportunity for you to persuade the judge of your position. So don't lose sight when you're drafting pleadings that a pleading is ultimately you trying to convince a judge to support your position. Remember that a concise pleading and affidavit is an effective advocacy tool. If you are filing 45-page affidavits, you might be concerned that you are going to lose the judge, both literally and figuratively. If you are including information that's not relevant, that is argument or opinion, the judge is then focusing on that issue and not the issue for which you have filed the pleading in the first instance. Now, this course, the CLE, is not getting into the content of pleadings. We're here to talk about form and some of the procedural requirements, but I will draw your attention, in case you have not had the opportunity to review and refresh, to Rules 106 to Rule 128, which relates to the content of pleadings. And I will just briefly flag that those rules form a fundamental part of civil procedure, and I would highly suggest that you take the time to review them. For example, those sections of the rules say things like, if you don't raise a ground in your original pleading, you can't it then limits the information that you can include in subsequent pleadings. And so I implore you to take a gander at those rules, even if this is not a course that delves into the content of pleadings. And one of the things I always suggest is take a view from a carpenter: measure twice and cut once. Remember that the amount of time you spend preparing and following the procedure helps ensure effective advocacy and access to justice, right? We're going to be talking in the remainder of the CLE about the implication of some of the procedural decisions that we make as counsel in relation to motion practice. I heard recently somebody utter a phrase that I quite liked, which was, the failure to prepare is preparing to fail. And so, remember, it is important to be considerate of the rules and the requirements that we are bound to live by through the rules of the NCJ. So let's delve into the specific rules and requirements for notices of motions and affidavits in the NCJ under the civil rules, the big rules. Again, I will flag that I'm hopeful that some of the things that we're talking about in this course, you will make analogies to more specific rules. And by that, I mean, know those rules, check those form requirements, love those rules. So I like to say that a picture is worth 1,000 words, and so much like last time, we are going to take a look at an annotated notice of motion form. So I'm just going to switch my screen here. Perhaps if I can figure out how to do it, someday I will get my on-site Zoom working, but not today. So let's take a look at an annotated notice of motion form. And once again, to confirm, my intention is to circulate this document as a PDF that you can have as part of the training. And so I'm not going to spend a great deal of time going through the portions of the pleading that we dealt with in the last session about the style of cause and things like that, only where it's, you know, there's practice suggestions for changes through interlocutory practice. So you will see that it notes the requirements for margins and 1.5 spacing, why you need to have a court file number. I will flag that I have contemplated that the notice of motion is being prepared in a proceeding where there is a like petition. I randomly picked one, but you would want to make sure that your general heading is correct and that your references to parties match the originating document that created the style of cause and general heading. Now, one of the things that you will note, you will see some text on these documents in purple. That's where I am suggesting tips for things that make a judge who is reviewing your documents' life easier. So for example, you will see in purple here, I have suggested that counsel ought to consider noting what the party's reference is for the purposes of the motion. So I will give you an example. There has been times when the registry has been provided documents where counsel has not made reference to who is the moving party on the motion and who is the responding party on the motion. And because of some other deficiencies in the pleading, the court was unable to discern which party was asking for what. Because for example, I recall a matter where there was a originating document. The parties were filing a motion asking for something on the motion record to be struck, and the references were jumbled. There was mistakes made and precedents that weren't updated. And if we had not known by mere happenstance, because the document was dropped off, we would not have been able to identify which party was requesting the document to be filed. And so it is helpful to help the judge understand who is whom in the proceeding if you are to make a reference to the fact that the petitioner is not actually the moving party, it is the respondent who is the moving party. And so that's what the suggestion is right here. Now, you will note again, in accordance with the requirements of subrule 15C, the document title is included, which is also a requirement of Form 25, which is the form that sets out the requirements for a notice of motion in the NCJ. Please note, this portion of the document, which sets out when you are requesting the matter be heard, or which is basically telling the court, this is how we want you to deal with this. This sets out that you are requesting, and again is a requirement of the form. You're telling the court when you want the matter to be heard. You may, for example, if this is a consent procedure, this is another one of those times that you could consider saying the parties are requesting that this matter be heard in writing or as directed by the court. I can add that before circulating it. It was just a lot of text to include on the document. And you will note that I am suggesting that you would import that change to say that the respondent is the moving party. Again, that assists the court in knowing who is doing what in the proceeding. You will note throughout the CLE that I'm going to say a bunch of times, these are things that you should think about because it helps make your point clearer to the judge, right? And that's a running thing that counsel, I would suggest you could keep in mind whenever you are developing pleadings. What can you do to make sure that it is easier for the judge to understand the point that you are trying to make? So, for example, one of the things that we're going to be discussing in terms of the procedure later, and so this is a little bit of a spoiler, there is no counter motion process in the NCJ. There are no cross motions. And so I often feel like sometimes there's a bit of dissonance because lawyers will receive a motion and they will say, but there's relief that I want and I need to be able to reply, and how do I do that under the existing rules? Since there is no cross motion or counter motion process, the process is to bring your own motion for relief that is not contemplated in response to the motion that opposing counsel and the circumstances follow. So if you are filing a notice of motion in response to a motion that you've received because you're seeking separate relief that is not available in response to the motion that your opposing counsel has brought, I would suggest that you could put at the same time as the motion dated X filed by the opposing party, or as soon as after that time as counsel may be heard. This flags for the registry that this is in the same file. We're going to be talking about the same things. Now you will note that that is for the judge to decide, for the court to decide whether or not they want to hear things at the same time. You may wish to turn your mind to whether or not that is something that would give rise to consideration for a special chambers appearance. And we're going to be talking about special chambers appearances. But that is the place, this place on the pleading is how you identify for the court how you want matters to be heard. And so, for example, I have seen counsel who have purported to file a counter motion or a subsequent motion asking the court to dismiss a motion that has been filed by someone else. And with respect, the appropriate process for that is to appear in response to the motion that was filed and ask the court not to grant the relief, right? So these are things that we can turn our minds to in terms of how the rules require proceedings. And again, when we get to the procedural portion, we're going to be talking about that. Important and interesting fact to note about motion practice in the NCJ. There is an oblique reference on the current form. So you will see, and this is the only instance where I've used blue. I like colors. I think they help make things clearer. But on the form for Form 25, the form says that you would say, take notice that motion blah, 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 and that the respondent moving party is seeking for an order that, and then it says state the rule or enactment relied upon and the grounds for relief. In the purple, I am suggesting that it is good practice to present that in a different way, that it makes it easier. One, it makes it easier for the judge to see the relief that you are requesting in a literal sense. If you include a heading that says the relief sought in the order is, and then you would set out a enumerated list of each of the relief. Now, that makes it easier for the judge to understand what you're asking for. But with respect, I think it is also an excellent way to establish your precedent because it reminds counsel that you are obligated per the rules of court to include in your notice of motion a list of the relief that you are seeking and a list of the enactments and rules that you are relying on. And I stress this because it is often the case that the court is seeing motions and pleadings in general, including originating documents, where counsel are forgetting to include the relief. And so if you are to refer to sub rule 382 sub 5, it specifically requires that you indicate the relief sought and that you particularize the provision in the enactment, that you pinpoint in your enactment, in your reference, to where in the legislation you are relying on. And I'm saying this slowly and trying to flag that people, there are judges in this court who will strike your pleading if you file it without referencing the enactment and without including grounds. So if you don't want to do it because the rules say, do it because you don't want one of our judges to strike your matter and say that you must refile once you get to court on Chambers. So I suggest that you consider including a list, one, because as we all know, judges love lists, right? When we get tests from the Supreme Court of Canada, it's a 3-part test. Judges love lists. It also just makes it easier to refer to. So technically, it is not against the rules to do a really, really chunky paragraph that has a number of semicolons that's really hard to read and refer to. But remember, this makes your life easier in oral advocacy as well, because you can turn to your notice of motion and pinpoint, cite, as it were, to that section of the pleading. As noted under the relief at paragraph G, we are relying on this provision of this rule, right? So again, your relief that you are seeking would be listed, and the grounds for the motion are this. So subrule 382.5 says that you are to include the relief sought. Subrule 382 also refers to the grounds for the motion. Now, one of the other things I'm going to politely flag is that it refers to materials. That contemplates if you are going to be filing a motion record, if you are going to file your memorandum of authority, right? If you are seeking, so from time to time, the registry sees pleadings where counsel wishes to include correspondence between the parties as grounds for a motion, and they want to attach correspondence for the parties to the motion. That is not appropriate. Correspondence should be included by way of affidavit evidence. And so if you are attempting to attach something to a motion that, or any type of pleading that is something that would normally be contemplated as evidence, so I'll give you an example. Under the Guardianship and Trusteeship Act, you are required to file with your petition certain documents. And so that accompanies the petition. But generally, if you are providing what would otherwise be considered evidence in the proceeding, that would be done by way of affidavit evidence. And so, if you are attaching something to a motion, be prepared to explain to the registry, or even better, when you send it in, say, I am attaching this in accordance with this. And if you have that listed in your grounds, as you should in accordance with Rule 382, that makes it easier for the judge to understand why that is attached to your pleading. Again, the motion form also requires that you list what
Sorry,
materials.
can I just ask a question before you move on?
Absolutely.
Thanks.
Please do.
Sorry,
Please
just
do.
about the grounds of the motion paragraph there. Are you saying that we need to specifically state that we're going to be filing a memorandum of authorities or motion record? I've always assumed that that's it's required in the rules, and so it's just it is expected.
So I'm saying, I'm flagging that when it says materials, it does not, sometimes counsel may believe that that refers to the evidence in support of your motion.
Okay, I see. So we don't need to specifically call out the memorandum of authorities. You're just warning against attaching evidence.
Yes.
Okay.
Now you will note that I will say this a number of times, I personally am a belt and suspenders type of gal. And so I would actually reference that I am going to be filing a motion record and a memorandum of authorities in my, and sorry, that reference to materials is actually how it's drafted in the rule, and these sections don't actually exist. So I would actually list the memorandum of authority under right here, under the references where I'm referring to the affidavit. But I would include that, one, because I would want the opportunity, I would want to make sure that the counsel on the other side is aware that I am going to be filing these things, so that when we stand up in chambers, counsel doesn't say, well, I haven't had the opportunity to put together, I wasn't aware that my friend was going to be preparing a written brief, and I would like the opportunity to do so, so I am requesting that this matter be adjourned. Belt and suspenders, Ms. Cudmore would then stand up and say, Your Honor, I noted on my notice of motion that I was going to be filing a memorandum of authorities, and I would like the motion to proceed as is. But
Gotcha, thank you.
Belt and suspenders, and this is not about content, but I like to make sure everyone is aware of what my intentions are. But that is a choice that counsel can make. I am flagging that if counsel is filing a notice of motion and it includes no grounds and no references to an enactment, you run the risk that your matter may get struck by the court. And there are certain judges in particular that are very particular about that requirement. Other judges may not be, but again, belt and suspender approach. If one, we are expected to be complying with the rules. My brain very much works in the sense that the rules say it should be there, so I'm going to put it there. But, note that this is a good practice to engage in, and I find that these headings on precedents help remind that information should be included.
Great, thanks so much.
Good question.
Hey, Claire, just a follow up to that. Also, I have Greg here for whoever's keeping track of who's in attendance.
Hi there.
When you want us to reference the memorandum of authorities, for example, that's usually filed after the motion. So would you suggest just saying like memorandum of authorities to be filed at a later date? Or how would you incorporate that wording to make sure that you're referencing the memorandum, which is going to be filed and not a previous one in the file?
So, fun fact, as is often the case, that answer is actually in the rules. So the rules actually state for interlocutory practice that if you're filing a motion under Part 31, you are not required to file your affidavits when you file your notice of motion. Counsel has a period of time, which we're going to go through in the procedural section. And fun fact that makes my brain a little itchy, personally, you're not actually required to file the exhibits with your affidavit. That is not a practice I would ever engage in, because I personally would be terrified that I would somehow misplace the exhibit or it wouldn't be properly certified. I encourage the filing of exhibits that are paper that can be easily attached to an affidavit at the same time. But technically the rules do not require that. So we're going to get into that, but great question. But as always, in very many ways, one of the things that it is important to remember is that we have, I'm going to age myself, but the original Nintendo had this like guide that had cheat codes and stuff that you could get. The rules of court are like a cheat code for all of these questions. And it is very rare that there is not a rule that provides procedural direction, which is why when I say read, 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 and reread, read the whole section. This sounds a little nerdy. I highly suggest that everybody read through the entire rules of court at least once, because there are nuggets and gems in there that you may have forgotten existed, or that may, apply in very rare circumstances. And so, they're a thrilling read along the lines of a Stephen King novel. Like, you will not believe some of the things that are in these rules that are tools that a lot of lawyers may not be aware of. So I'm a huge proponent of the rules of court. yes, I am this nerdy in real life. So if that answers your question. I'm gonna assume
we'll
yes,
keep going
because I
and we'll
hear
see if we
you.
need to come back, but I think we're good.
Awesome. Okay. So the form also requires that you list the name and address of each person to be served. And again, this is one of those situations where this form actually includes the two. Not all of the forms do. And so you don't need to include that information on your backer. Note that on the backer, I am suggesting that for the purposes of the notice of motion, that again, you would endorse who is the moving party and who is the responding party on the motion. And then as we went through during the last course, the particular requirements of the backer. So that is the notice of motion form. And again, I'm going to point out that this is your first opportunity to persuade the court, to start persuading the court for your position, because you are telling them, this is what I'm asking for, this is why I'm asking for it, and I'm suggesting that these rules and enactments are on my side when I am making this argument. And here is all the beautiful affidavit evidence that I'm going to be filing that's going to support the position that I am taking before the court. So motions that are filed in this form are much clearer and easier to bring the court through those requirements. So if there's any questions about this particular form, I'm happy to discuss them. If not, I'll flip to an affidavit.
I have my hand raised, Claire.
Oh, Keith.
I'm not sure if you could see it.
Sure.
Right. So first off, thanks. I'm very happy that we're going through this, because most of the time you just pick up a precedent and you just follow whatever they did in that particular one that's most analogous to your case. My question, I'm still hung up a little bit about Rule 382. So you said that we need to pinpoint specific provision in a legislation, because what I've seen, and I've never seen it done the way you suggested it, but what I've always seen is just like, the moving party pleads and relies on, contributory negligence, or sometimes you will just list just the legislation, right? And you don't make any specific provision as pinpoint provisions. So are you suggesting that we need to put section 25 of this, like occupiers liability or contributory negligence act, like that kind of position?
So again, this CLE is about the requirements of form within the rules, and I'm not able to get into specifically, a discussion, although it would be thrilling and I would love to in other circumstances, but about the specific content of pleadings and how you're deciding which relief you're asking for, or which pieces of legislation or liability you're trying to rely on. But I will point out, and again, we're talking about motions and not statements of claim or originating documents. But if you were to look at sub 5 in Rule 382, a notice of motion must state, and see how I have my rules open because they live on my desk. You want to have them available, easily referenced all the time. A notice of motion must state the particulars of the order sought and the grounds to be argued, and hear the bolding in my tone, including a reference to a provision in any statute or regulation or these rules relied on. So the rules require more than just saying, I'm relying on the Children's Law Act. The rules require that you point to the specific provision or provisions in the legislation that you are relying on. And again, there are judges in this court that if you send in a motion that just says, if I'll give an example to the lengthiest document that I can think of, which is the Nunavut Land Claims Agreement, right? I don't know what motion you're filing, but if you just say I'm relying on the Nunavut land claims agreement and not which particular articles you're relying on, there are judges that would send that back and say, no, I'm not guessing which one you're relying on, point me to it. If that is helpful.
Yeah, I think it's the plain wording of the rules does suggest to, reference to a provision. So that makes sense. I guess the resistance for me is based on two things. First is that I've been used to just citing legislation and it's never been an issue. And second, I'm worried that a pinpoint might restrict me from using the entire legislation, because then I just said, oh, I'm relying on this particular provision, but then I'm afraid that what if you miss something within that legislation that you also need, right? So maybe it's also massaging the wording of I'm relying on the Contributory Negligence Act specific to this provision and any other provision, or I don't know how to word it, but I think there might be a way around it.
So I can tell you that when I was starting in practice, and I can tell you that one of my articling principles often pointed out the importance of including the words "such and other further relief that this honorable court deems just." Right? So.
And I love how Corey just has almost the same wording as that.
Oh, awesome. I don't even have the chat open. It is such
Thanks, Corey.
There we go. If I could high five you, if we were in person, Corey, there would be a solid high five happening. So amazing. But this is
love a
also
Zoom high five.
One of the Zoom high five. But one of the things that I hope that this CLE encourages is that we as members of the bar can have conversations. Don't ever feel like you can't reach out to someone that engages in a litigation practice. We don't have to have specific discussions about files, but raising issues like that, because sometimes you get a precedent, and people that work with me will probably tell you that one of the things that I say the most is, that's not Star Trek related, obviously, is that there is no such, to me, there are only two answers to a question that are wrong. And that is, if I ask you why you're doing something and you say, because that's the way it's always done. And I raise that example because sometimes we get precedents and they may not be correct, right? And so one of the reasons why I wanted to do that annotated review of the form is to make sure that we turn our minds to why these things are required, where in the rules it happens, right? So I love a good civil procedure discussion, and I love, taking the opportunity to say, oh yeah, like why do we do that, right? And the such and further other relief as counsel may advise, or this honorable court deems just, like these are things that we do because we're not perfect. And maybe we forgot something, or maybe something comes up. So, talk with each other about civil procedure, read case law. Like, I'm not going to lie to you. If you ever want to have a fun weekend or Friday night, pop some popcorn and search on CanLII or LexisNexis, application to strike statement of claim. Like, there are some thrilling things that you can learn about the importance of civil procedure by reviewing case law about civil procedure, right? We all make mistakes. Sometimes those mistakes become precedential decisions that are referred to in terms of how not to do something, right? So learn from people is really what I love. Okay, so any more questions about notices of motion? Okay, so I'm gonna pop up an affidavit, and one of the fun, where did it go? My computer is telling me that my affidavit is not open, but it totally is because I am looking right at it. Standby, technical difficulties. There we go, here it is, it popped up, good job. Okay, so I'm gonna try and make it so that I can see you guys at the same time. Hopefully the world doesn't fall apart. Okay, so fun and slightly less than helpful fact. There is no form for an affidavit in the rules of the Nunavut Court of Justice. And so, but part 30 of the rules is all about affidavits. Part 30 is your friend. And part 30 is very clear about the requirements of form. And so I have drafted a precedent document. Again, this is just a general heading and style of cause that is based upon really fakeness to have something to refer to. So again, there's no form in the rules, so there's no form number at the top, but the requirement for spacing and margins still the same. And we want to make sure that our references are the same as the notice of motion you are filing. Again, the purple suggestion that you help the court understand who is who in terms of the matter before them. You're required to include that document title. Now, fun fact, subrule 3671 requires that in Nunavut, you are naming not only the deponent, but the occupation of the person who is making the affidavit. So I note that requirement is there, and sometimes it's not a requirement in all jurisdictions, and so please make sure that you are including that information. Make oath and say or affirm, because people can make that choice. But again, the start of the affidavit is a requirement of subrule 3671. The rules also require that paragraphs are consecutively numbered. Now, I am going to again stress that this CLE is about the form requirements of affidavits, because we could probably do a whole week, of course, on the substantive requirements for content of affidavits, okay? And I realize that would be an amazing class, but that is not today. So consecutively numbered paragraphs. One of the things that I would like to flag and draw your attention to is the requirement of subrule 373.2, which says that where information is based on information or belief, you must note the source of the information or belief. And I flag this, one, because it's a rule and you're supposed to do it, but I also flag it because the court has noted that many counsel in preparing affidavits forget this requirement. So blow their socks off and make sure that you're including that information in the content of your affidavit. So don't forget rule 373.2. After we go through the form and we talk about procedure, we're going to talk about some tips and things to consider when you're drafting affidavits. One of the questions that we often get, and one of the things that we see, is there's a practice in some jurisdictions of including a statement at the end of affidavits that says, I make this affidavit for no improper purpose. That is not a requirement in Nunavut. I can tell you that conventional practice and the court's preferred practice is if affidavits are ended with the final paragraph, this affidavit is made in support of an application for the following relief. And I will point out that if you have affiants that are providing evidence in relation to different grounds of relief, this is helpful because it allows the judge, when they're reviewing your notice of motion or application, to understand whose evidence you are suggesting applies to which area. So again, not a requirement, but something to consider that is helpful for the judge that you are dealing with. I'm also going to point out again that there, in a way, again, that makes my brain a little itchy, there is no requirement in the rules for you to include page numbers in your documents. I would strongly suggest that you consider including page numbers. And here's the very practical reason why. As most of you know, many of the lawyers in this jurisdiction take advantage of Practice Directive 18 and email documents to the registry for filing. So that means that when we get the document and we're printing it, it is not stapled or bound. And if the clerk is walking from the printer to the desk to collate your documents and they drop it, it can be a problem to determine which goes where and what applies to what. So just in case things get a little bit wonky, page numbers are very helpful. So please consider page numbers, particularly if you have a lengthy affidavit. Now, let's talk about the jurat on a affidavit in the Nunavut Court of Justice. There are particular requirements in the rules about the content of the jurat. You have to include where the affidavit was sworn, that it was sworn, so if it was sworn in Nunavut, as it is in this precedent, but you also have to include the date that the affidavit was sworn, and that's a requirement in Rule 369. But let's just talk about why that's important. One of the things that counsel needs to remember is during the life of a proceeding, you can actually have multiple affidavits from the same affiant. And so if you are trying to refer the court to an affidavit of Clare Cudmore, and there are 7 affidavits over the course of the proceeding, if there's no date that the document was sworn, it makes it extremely challenging for you to refer to which affidavit. So the reason I suspect that rule exists is to ensure that you are able to refer specifically to a specific affidavit. Please do not forget it. The rules also require, Subrule 368.2 requires that the name of the commissioner or notary is printed under the signature. And that is so if there is a dispute as to the validity of the swearing of the document, it is clear who signed it. Now, I am going to point out one of the things that you should be checking is to make sure that you are ensuring that documents are commissioned with the person in the room. Subrule 368.1 requires that documents are sworn in person, and there was a brief period of time during the pandemic when the court had a direction that allowed remote commissioning. That is no longer the case. And as we talked about in the first training, it is important to ensure that your precedents are from the Nunavut Court of Justice and refer to Nunavut matters. I cannot tell you the number of times that the registry receives affidavits that have the commissioner sign, and it refers to a regulation in Ontario that allows for the remote commissioning of documents. That's not great in terms of practice, Corey. And I beg leave to refer to you by all of your first names because I don't want to make assumptions about gender. So Corey?
That's quite all right. Thank you. Not to be that person, but can you maybe talk a little bit about what it is in 368 sub 1 that makes remote commissioning not be permissible?
So it's 368 sub 1, but also the Evidence Act of Nunavut. So you will see, sorry, I'm scrolling. I was at 389. Stand by. So the court requires that the person be before the individual, and there is no definition or any indication in the rules that it allows for the interpretation as that being remote. And the court is quite firm that there is no ability to allow for remote commissioning in the absence of a dispensation by the court or regulation that would permit that.
Great, thank you.
No problem. Which is also a great way of reminding counsel that the Evidence Act applies. And the Evidence Act of Nunavut is quite clear that in the event, absent, because the law is never simple, right? There are particular exceptions, but as a general rule, if you are having an affiant who is outside of the territory swear an affidavit, that the Evidence Act requires that that be notarized. Again, there are some particular exceptions, but be prepared to defend when you're filing documents. The court has empowered has informed the registry that they are to reject any affidavits that are not sworn in accordance with the Evidence Act. And so if you are filing an affidavit that is being sworn outside the jurisdiction, and you are relying on any of the provisions of the Evidence Act that would allow that to be done by someone other than a notary, I would suggest when you are filing the affidavit with the registry, you note that you are filing it on that basis, because they will return the document and ask you to confirm whether or not why you are filing it without it being notarized in accordance with the Evidence Act. They are prepared that there is an answer, but you must provide them that answer. So please take the time to review the provisions in the Evidence Act about who you are having swear documents. Because again, as we discussed at the beginning, all of this delays, all of this back and forth, these challenges delay your ability to file the documents, especially if you have the document commissioned and then you have to go and find a notary to notarize the document in accordance with the Evidence Act. So keep in mind that that's a requirement. Also, fun thing to remember, your backer should be after the exhibits. Also, the exhibits have to be certified by the person who is commissioning who is swearing the affidavit. And so one procedural thing I will note is there is currently a practice where counsel will send documents to be notarized or commissioned, and the commissioner will file a separate document. So there'll be a blank page in front of the document that's being referred to as the exhibit, and the blank document will say, "This is the exhibit. I confirm that this is the exhibit." The preferred practice is that the commissioner or the notary endorse upon the copy of the exhibit. Again, because if you are filing just as a matter of confirming that that is what the commissioner saw, but the challenge is if you are filing, again, sending the documents electronically, and the judge is referring to the document, and there's this certification attached to what, right? So consider whether or not that exhibit stamp will fit on the document. Again, we're going to get into some more nitty-gritty details, but remember also to reference Rule 378 if you are filing an affidavit that does not include exhibits that are referenced in the document, because the registry is going to check just out of politeness, because sometimes y'all forget to attach your exhibits. And so the registry will respond and say, "We note that there are exhibits referenced. We're returning this. Did you wish to send it with the exhibits?" Just because if you think you filed them, you may not know that you need to bring them at the court appearance. So reference Rule 378 if for some reason you are not attaching the exhibits at the time that you are filing an affidavit. So that just brings us to the backer, which would be, again, after the exhibits, if any are attached. Any questions about affidavits? Okay, so I'm just going to stop my screen share. I'm going to flip to the other screen with the fun PowerPoint, and this is the point where I cannot see you guys. So I think apparently I was clicking while I was doing the presentation. So at this point, we're going to be talking about practice tips and procedural rules for when we're dealing with notices of motion and interlocutory practice. So I thought it would be helpful if we review what happens when a notice of motion is being considered in the NCJ. Now, note the court has practice directives that apply to chambers practice, and that is PD 32 and 33. Please don't forget that those exist when you are filing a notice of motion. So what happens? A party to a proceeding decides to seek interim relief of some kind. So you, as the moving party, file a notice of motion and affidavit evidence. Now, again, the rules give you some time before you have to file your affidavit evidence, but when you are filing your notice of motion, I suggest that it's good practice to consider, are you comfortable relying on your notice of motion and materials? I say ask that question because I find from a belt and suspenders approach, consider a world where the court makes its decision based on your written materials. Are you comfortable that you've included everything? Are you comfortable that that affidavit is crisp, that you've included all of the information that you need? Also, and again, we're going to get into some of the rules here, remember that any affidavit that you file is subject to cross-examination. I say this, and again, we're going to get into some detail, but I say this so that counsel turns their mind to the issue of hearsay. So are you content that your evidence is going to make it before the court and be reliable on if the person who is filing the affidavit is cross-examined? Consider how you're best presenting your evidence. For example, have you considered a motion record? We're going to talk about that. So you file your notice of motion, and you as the moving party are then awaiting the response, if any, from the responding party. And then you're going to try and make your case to the court. So the responding party gets your notice of motion, is aware that either accompanied by affidavits or anticipating affidavit evidence. And the responding party gets to decide whether or not they want to engage in cross-examination in accordance with the rules of discovery in the NCJA civil rules. And again, recall that traditionally, absent exceptional circumstances, cross-examination on motions happens outside of court. The court is not involved other than if there is a cross-examination, transcripts of that cross-examination can be filed with the court. The responding party considers whether or not there is relief that they wish to seek in relation to the subject matter of your motion, the counter process. And again, that is, please note, if it is relief that is not available to them to ask in response to your motion, or the responding party decides whether or not that they're going to be filing affidavits in response. The responding party theoretically could also decide whether or not they want to consent to the relief that you're requesting, or they may just wish to file nothing but oppose, file nothing included for affidavit evidence other than their required memorandum of authorities under Rule 390. And then they may stand up and say that they are opposing your motion. Or the responding party may not consent, they may not show up, and you may ask that the motion proceed unopposed and you request the relief from the court. So once the matter proceeds to the court, the parties rely on the evidence before the court. So the affidavits, the transcripts on cross, the brief and materials, unless the court permits other evidence. But it's important to remember that the court may be asked for a matter to be adjourned to deal with cross-examination, right? So that's where counsel needs to be remembering. One of the important things that we always need to consider is, did the fundamental rules of natural justice, did the opposing party have notice? So don't forget your affidavits of service on the file. You would not believe the number of times counsel forgets to provide proof of service on the responding party. So have you prepared a draft order for consideration, right? This is 2023. It is really helpful. It sometimes puzzles me why counsel doesn't bring a laptop to court or bring a laptop with them so that you can prepare, you can update or modify your proposed draft order to have it to the judge within minutes of after your matter is proceeded, right? Up to you, but don't forget that an order, you're hoping that an order may come out of whatever you're doing, or if you're opposing, that no order issue. So, but always ask yourself the question, can this be done in writing? The court in Nunavut is very open to matters proceeding by way of basket motion or in writing. And so you can, as we discussed for the originating documents, you can ask that a matter be heard in writing unless otherwise directed by the court. If you and counsel disagree as to the relief, but you agree that you don't need to appear and argue, that your briefs are beautiful, your affidavits are beautiful, you think the court is well equipped to make a decision by reviewing your beautiful documents, please feel free to ask. Again, ultimately, that's up to the judge, but the court is very open to that process. So understanding the flow of the motion and knowing, again, if the responding party decides to file a competing motion, like a motion asking for something separate, again, the court gets to decide if they're heard at the same time. You can ask, but the court, the moving party may object. The court may have to consider whether or not that's appropriate, but you get to make that ask. So, like we talked about, there is no counter motion or cross motion process in the NCJ. I have seen a number of counsel try to take the Form 8 and use it for motion practice. There is no counter motion process in the court. And you will see there's no process in the rules for a counter motion. Like, what happens if somebody files, if we don't have a counter motion, what happens in terms of requirements and timing for pleading, right? So, like we just reviewed, you can consent to the relief requested. You can file an affidavit in opposition. So sub-rule 383 sub 3 allows the responding party to file an affidavit in opposition. Okay, it also, sub-rule 383, this whole section of the rules sets out timelines for filing affidavits and responding affidavits with motions. So Joanne, there is your answer, right? If you, and in accordance with the rules, you can in your notice of motion reference an affidavit that has already been sworn or an affidavit that you intend to have sworn. So you don't have to say the affidavit of Clare Cudmore sworn June, I don't even know what today's date is, people. June 6th, let's just say June 6th, there's a number. But you can say the affidavit of Clare Cudmore, and then 10 days before your motion hearing, file that, serve that affidavit on counsel and file it, right? So again, the rules tell you what that timeline is. Now, this is where I'll save because I've got another slide. I'm getting ahead of myself. But the thing to consider when filing a separate notice of motion is whether or not you need to do that, because the rules give direction on what you are permitted to ask for during the motion process. So is it relief that's available on the grounds that are before the court? And so if you are asking the court, if somebody files a motion, for example, for summary judgment, or if somebody files a motion to set aside that they've been noted in default, and you wholeheartedly disagree that they should be noted in default, you do not need to file a counter motion asking the court to dismiss the first motion, right? Remember that with motion practice, motions can proceed unopposed, but you can also oppose them through the motion. You can ask the court not to grant the relief requested by the moving party. I will point out that there is a fairly interesting recent PEI Court of Appeal case that I don't have the exact reference to. RVR, I don't have it off the top of my head, but you should read it. There's a really interesting appeal that just happened in PEI about whether or not a responding party can ask for summary judgment against the moving party who has asked for summary judgment. Anyway, very, very interesting procedural case. But the other option is to not reply, because that's a decision and you can not, the matter can proceed unopposed. So if you see like this right here, remember the processes to note someone in default is not available on motion practice. You cannot ask the court to note somebody in default rather than proceeding with your motion, because the process is that the matter proceeds unopposed. There's no requirement in the rules for someone to file a reply to your motion. They can choose to file a competing affidavit. Technically, they're supposed to file a memorandum of authorities, but if they're not relying on anything other than saying, I disagree and you ought not to file this motion, they technically don't have to file anything. So always, if you're considering asking the court to note somebody in default, I find a fun way to remember whether or not you can do that is to ask, at any point in this proceeding, was the person told if they didn't reply that they could be noted in default? Was there a notice to defendant, for example? So, and also don't forget, as Corey pointed out, there is a requirement in Rule 390 that both parties file a memorandum of authorities. And in Rule 391, for special chambers, there's a requirement for pre-hearing briefs. So when considering that process, I do want to flag the right to cross-examination. So Rule 383 sets out the requirements for service. And people, some of those timelines are really tight. Like in theory, you could file an affidavit 5 clear days before the hearing. You can file a responding affidavit 3 days. Now, the thing to remember, though, is that any affidavit that is filed is subject to cross-examination. So if you are filing your affidavits on that tight timeline, you run the risk of the moving party requesting an adjournment so that they can cross-examine on those affidavits. And again, the cross-examination process under Rule 381 follows the rules of discovery in the rules. So it happens outside of the court. Right? So it may be a better practice to file your affidavits with sufficient time for the responding party to decide whether or not they want to engage in cross-examination. And again, please don't forget, proof of service is so important, right? You want to be able to stand up and say, this was served, they had notice, I filed these affidavits 3 months ago, Your Honor. And the time for cross-examination, with respect, in accordance with Rule 381, I suggest that my opposing counsel has not exercised reasonable diligence and you ought to refuse the adjournment. So remember, there are timelines in the rules and you're not required to file your affidavits with a great deal of time before the hearing, but consider the practical implications of that in terms of delay. Helpful tips. Have you included all your grounds on a notice of motion? Have you listed the affidavits that you intend to rely on? One of the interesting things that can happen procedurally is if you try to file additional affidavits that were not noted in your notice of motion. Again, we're not getting into the legal issues about content, so I'll leave that for you to percolate on. But, there's a mistake on my slide. I'll fix it for when I send the slides around. But when you're talking about oh no, there isn't a mistake. I hit a button. There we go. There is a mistake. That's from the affidavit slide. But there we go. If you are filing an affidavit, one of the things that counsel should turn their mind to, that we see a lot, is the issue of hearsay. So for example, you get a administrative support person in your office to file an affidavit, and the affidavit says, I am advised by the lawyer that their client told them this, right? Remember, every affidavit is subject to cross-examination. You are subject to the rules of evidence and the rules surrounding hearsay, and picture how the cross-examination of your assistant would go. if that is the affidavit that you are filing. So remember to consider how you are going to get the evidence in when it is subject to cross-examination. Like we noted, information and belief. If the rules require that you cite the source of the information and belief in your affidavit. Don't forget about the quality of your exhibits. If you are asking the registry, if you're scanning documents and emailing them to the registry, are you asking the registry to print a scanned copy of a blurry photo? And remember how the commissioner is certifying that exhibit. Fun fact, and people, this has happened. Sometimes for various things, counsel files screenshots as exhibits. Don't forget that if you are screenshotting a website and you have tabs open, the court can read those what it says on those tabs, and sometimes there have been instances of embarrassing information on those screenshots. So don't forget to take a good view of exactly what you are capturing, right? If your Star Trek fanfic is open, make sure that you close it. Also, remember concisity, right? You long rambling affidavits, you may lose the judge both figuratively and literally, right? In addition to the requirements in the rules about the content of pleadings and the content of affidavits and the rules of the laws of evidence, right? You want to be as effective as possible to try and make your arguments. Now, one of the things I mentioned earlier that, and I'm cognizant of the time, I'm almost done, is consider doing a motion record. There is no form for a motion record in the rules, but the registry does accept them. And the court has a strong preference for them. Again, think about it from the perspective of how much easier it is for a judge if you've got all in one document, your motion record, all of the affidavits, the cases that you're asking the judge to rely on, your brief, all in one spot. And so it is perfectly acceptable, if not encouraged, to prepare a motion record. You can include your notice of motion, all of your affidavits, you can serve that one thing on the other party, and there is all your, like one beautiful affidavit of service to prove service of all of those things. Now, I will point out, please take a moment to confirm whose motion record it is. When you're filing things, I know that in other jurisdictions, for example, where there's not as much emailing of documents that we then print, you're filing a blue motion record for the moving party and a red one for the respondent, or buff, right? So the color, if you forget, will tell you whose it is. But I have seen motion records, again, where it says motion record and both parties are listed and nothing else. So moving parties motion record, bold the party's address to indicate who it is, right? Don't forget that you want to help the court understand who is making the argument as much as make it easier for them to access the information. Now, if you are filing a motion record for special chambers, always have a hard copy for the judge. If you have for special chambers got leave to approve remotely, to appear remotely, you should be sending that in advance so that the judge has the opportunity to review it. If you're sending a PDF of a motion record, if you are able to do so, and not everyone would have the technological ability to do so, but like the booked PDFs where you can combine documents and put it with bookmarks and things like that, all of these things make the judge's life easier. So let's talk about chambers dates. So practice directives 32 and 33, they are your friend. One of the important things to remember about practice directive 32 for regular chambers is that practice directive is contemplated specifically so the court has enough time to review the matters that are proceeding. So if you want your matter to proceed, please send your motion confirmation. The direction of the court is they have to be received. If you're appearing in Nakaluyt on Monday for regular chambers, Wednesday at 4:30, because the practice directive says 4:30. By Wednesday at 4:30, you have to file that 32A or it's going to be struck. And that is because the registry prepares all of the files on Thursday, and then the judge has the opportunity to review your beautiful, beautiful documents before the appearance on Monday. Now, I will also note, sometimes counsel have matters that appearing on circuit. The practice directive doesn't differentiate, but turn your mind to the fact that the court leaves to go to communities on the weekend before. So if you haven't filed, even if your matter is on Thursday in Kugaruk, you really want to think about confirming on the Wednesday before so that the judge knows, I'm going to look at your beautiful documents over that weekend, right? So turn your mind, even though the requirement doesn't say, try to get this done before the court leaves, think about it, because it means that judge is looking at your beautiful arguments and your perfectly formatted affidavits for the entire time beforehand, right? I'm also going to point out, because sometimes there is confusion, Practice Directive 33 contemplates one 33A. A 33A is the form that you're using to request a special chambers date from chambers. And I say this because counsel are expected to work together to determine which dates both counsel are available. That is what the form requires. Please do not file two 33As where you list your dates and then the opposing counsel lists all their dates and you don't have any of the same dates. So please take the time to speak with each other. And if there is challenges between the parties in securing a date, you can request a case management, right? Or suggest, consult with the trial coordinator if there's a judge available to help with the issue of setting dates, right? So all of this helps with confirming efficiency. I am also going to point out, because sometimes we see counsel get a regular chambers date for this month, and they indicate that the matter needs to be adjourned, and they ask that the matter be adjourned to next month. Don't forget the beauty of adjourning sine die. It is a lot of paperwork for you and time for you to be appearing to request an adjournment. We do see counsel confirm that they wish to appear and then request the matter to be adjourned. And I don't know if that is because there are a great deal of practitioners in the Nunavut bar who practice both criminal law and some civil law, and there may be a leftover expectation from criminal law that there's some jurisdiction that's being lost. But remember, you don't have to reserve your affidavits. All you have to do is request a new motion date, right? So take a look at Practice Directive 32. It's there to help you. So remember, if you're just setting things over and setting things over and setting things over, that's generating a lot of paperwork and not necessarily a great use of judicial or your own time. So I am flagging specifically, sine die, it's your friend. So let's think about what causes delays in chambers matters, because some of it relates to procedure and to form. One of the biggest one is service. A notice of motion is, absent exceptional circumstances, supposed to be on notice. So the court is going to check to see if the other party had reasonable notice. Don't forget to file your affidavits of service. Don't forget to consider the timing of filing affidavits in relation to cross-examination, because that's the other issue. Sometimes more junior counsel might expect that witnesses are going to be called at chambers, and that's the opportunity for cross-examination. But in accordance with the rules, cross-examination in motion matters, absent direction from the court, proceeds by way of discovery. Your confirmation and time estimates. Remember that the rules require that anything that is going to take more than 30 minutes proceed by way of special chambers application. And remember, that 30 minutes is not, I'm going to take 30 minutes and talk. That's 15 minutes effectively for both parties. So turn your minds to how effectively you can use that time if you're seeking a regular chamber state. Because if the court does not, if it is clear, if you file a motion, a 32A for a regular chambers appearance that says that you expect that your motion is going to take an hour and a half, that is getting struck, and you are going to be directed to file a 33A, and you've wasted your time that if you had asked 2 months ago when you requested that regular chamber state, you probably could have gotten a regular chamber state, which is something that I will point out. The Nunavut Court of Justice is a fairly nimble jurisdiction for civil matters. If you have a notice of motion and you want to cross-examine on an affidavit, remember, if you're seeking direction from the court under the discovery rules, requesting an answer or an undertaking, there's a regular chamber state next month that you can ask to appear upon to deal with those issues. So remember, there's space for civil practice in Nunavut in the court schedule. The other thing to remember is remote appearances versus in person. Okay, Practice Directive 4 and Practice Directive 33 are very clear about the circumstances where people need to seek leave to appear remotely. The presumption is if you have a special chambers appearance that you are going to physically be present in Nunavut at the court location that you are requesting that special chambers. If you do not, you are required to file a notice of motion seeking leave to appear remotely. And again, that request can be made quite nimbly on a regular chambers that happens once a month. Okay, the registry has a helpful, colorful tip sheet about things to consider for maintaining civil chamber states. I will be circulating it, and it is available upon request. So, the things to remember: read your rules, have the PDs handy, read and reread them. Okay, don't rush. Take your time to review the rules. They're there to help you, and they have many of the answers. Make sure that you're referring to NCJ rules. Again, you would not believe the number of times that we receive documents in this registry that start with in the Ontario Supreme Court, or again, I should have looked up what the references to the other courts are in terms of court titles, but the general headings refer to other courts. So, or there's forms or like under other jurisdictions' rules that aren't part of our rules. So, and remember, if the registry sends you a document back that it's not stamped rejected, it's a sign that there are issues that you may want to correct, right? There's something that maybe they're just checking in case you've forgotten something. And it is 100% okay to be prepared to answer the question why you're doing things this way, right? When the registry says, we note that there are exhibits referenced in the affidavit that are not attached. The registry knows that you're not required. They're just checking to make sure in case you've forgotten, right? Because if you've forgotten and it delays matters, it's not good for anybody. Also, keep track of your deadlines in terms of maintaining chamber states, in terms of the requirements for filing documents in the rules, because when you forget those things, it causes delays, right? Also, it's just not a great feeling, right? It's the worst when you've forgotten that you were scheduled to be somewhere and you get the call, right? The court is wondering where you are. So, it is your calendar is your friend. The worst part about this presentation is I spent more time than I should probably admit looking for a funny cartoon or something about civil procedure or like filing documents or affidavits, and I could find nothing. So there is no funny tweet or cartoon at the end of this presentation. So thank you so much for coming today. I'm just trying to get back so I can see all of your, I was going to say beautiful faces, but it's all just your names. I can see Bruce McRae's face because he has a photo. But does anybody have any questions? Bruce. So just to confirm, I will circulate the annotated notice of motion and the affidavits. I'll correct my wonky slide and circulate the slides in case people think those would be helpful. Okay, well, happy Friday. You're very welcome, Bruce. I'm super happy to see so many people here. And again, next week, we're going to be talking about trial practice under the civil rules. And that presentation is going to be edge of your seat thrilling because there are so many requirements and things to consider. And if anybody ever wants to have a academic discussion about civil procedure or rules, you're welcome to give me a shout. Thank you so much for your time.
Thank you. Thank you, Claire.
You're welcome. You're welcome. And Corey, I can just, oh, I think he left. I'll email him. Okay. Thanks. Thanks, Nalini.